Thank you, and good morning, good afternoon to those in London and on the other side of the ocean. Thank you for dialing in to our session on SEC investigation response for asset managers, how to prepare and mistakes to avoid. I am Shari Griffin, Senior Vice President with Willis Group as part of the Financial Institutions Group here in New York, and I am pleased to introduce our Head of Global Financial Institutions, Mary O'Connor, who will make the welcoming remarks for this webinar. Thank you for your participation. Mary?
Hello, everyone. Thank you for attending the webinar. I'm hoping this is going to be the first of a number of calls. This space is very important to us, and we recognize that you all need information about some of these key issues, and we're hoping that we can help you with that. Our next call is actually going to be July 17th, discussing cyber, so the first of many. Just a couple of introductory remarks. I was a prosecutor for a long time in this space, and I think I can safely say that the prosecutors are targeting this space very hard. There's two reasons for that. One is that the demographics are pushing it as people are moving towards retirement and as there's an expansion of the sector around the world into new areas. That's pushing prosecutors to start to focus quite hard on that, and the numbers back that up. The second is that the regulatory priorities now are two things, consumers and markets, and this space hits both of those very hard. The regulators also have more tools to do it. There are a number of firms that they have been looking at for years. So, Harbinger, 2013 results. That's the sector that the market tools and the assessment that they were doing, was throwing up, and they were for a long time focusing on insider trading and how they could go after that. But now they've got a lot of systems and controls things that they can look at as well. And the big thing I would point out to you is, one, they're getting better at the insider trading because they've figured out how to do that well. And the second is the systems and controls cases are a heck of a lot easier than the insider trading cases. So, once they open up an investigation, they have a pretty high degree of confidence that they can turn something over that will be at least of interest to them, in terms of their desire to get prosecutorial results. And then the last two things I think that are of big influence is international cooperation. This talks about SEC investigations, and I do think that should be your primary thought. The U.S. authorities, like it or not, are still have the biggest hammer in terms of finding ability and in terms of the ability to go for criminal penalties. But the minute they open up that investigation, you better realize that they are talking to their international colleagues. So if you've made an investment abroad, which would target you with jurisdiction somewhere, or if you have offices abroad, recognize that box is going to be open. And there's some really key things like Fifth Amendment privilege, cooperation that you really need to think about, particularly with the new SEC policy on admissions. You need to be really focused on where this could go right from the get-go. And last but not least, individuals. I prosecuted the first case against an individual for not being good at his job effectively when I was at the FSA. And I think that the prosecutors that I talk to now are very focused on the fact that it is difficult to get the fines high enough up without doing material damage to the economy. And one of the things that they're trying to do to change behaviors, or what they see as potentially wrongful behaviors in the market, is to target individuals. So, those factors, I think, make this very timely. You've really got to be on your toes, because when and if they do come calling, you need to be ready. So thank you very much, and I'll turn it over to the speakers now.
Well, I get the honor. This is Richard McGranwell. I head up our Financial Institutions Group here in the U.S. for Willis. And I get the honor of introducing our distinguished panel and setting the stage a little bit for our topics of discussion. I have to say, though, that it was Sandra Day O'Connor who said that there's no shortage of lawyers in Washington. In fact, there may be more lawyers than people. We have all lawyers on our panel here today, so you'll have to excuse our plethora of lawyers here. We have Chris Lombardi joining us from Kinetic Partners. If you're not familiar with Kinetic Partners, they're one of the leading consulting advisory firms in the financial services industry with 8 global offices. Chris is a lawyer with a former compliance officer with 13 years' experience, discussing key areas of SEC scrutiny. Joining us from Schulte Roth, we've got Gary Stein, a partner, and Ted Keyes, special counsel. Everyone knows Schulte Roth and Zabel. offices in Washington, New York, and London. The firm's practice is focused on financial services. I'm not sure the latest number, but over 350 lawyers, I hope that's about right, and representing over 3,000 investment funds globally. Next, we will have, and Gary will be talking about SEC enforcement actions. Gary's practice focuses on white-collar criminal defense and SEC regulatory matters. He's a former U.S. attorney. We will have Ted talking about insurance implications, SEC policy of admissions. Ted's practice covers the full gamut of insurance issues, including D&O and professional liability. Finally, we will have Robert Henry talking. He's a VP at Axis Insurance, financial institutions product manager, yet another lawyer, with 15 years experience underwriting with Travelers and Great American. Is that right? Axis Insurance has operations across the globe and offers virtually all major lines of coverage for investment firms. And he'll be discussing fund managed coverage issues. Okay? With that, I'm going to turn it over to Chris to jump right in.
Okay. Thank you, Richard. Thank you, Mary. Good morning. Good afternoon, everyone. Again, we look forward to holding this panel today. And what I'm going to focus on to start is basically I'm going to cover what we're seeing in sort of presence exams, as a lot of you may have heard about that. The Office of Compliance Inspections Examinations Division, or OC, at the SEC has been conducting for the last few years. I'm going to cover a lot of the key topics we see that we go through with our clients, and as we've read, as a lot of you have, some of the key areas that are being focused on and some of the results of these exams. And what I'll talk about is less on getting it to sort of an enforcement or prosecutorial stage. I'll let Ted, Gary, and Robert will sort of get into that, where if things can go wrong in these presence or routine exams, how it can lead to sort of enforcement, liability, and then insurance concerns. So basically, the last 2 years or so, the SEC, well publicized that they would be carrying out this national exam program, or a lot of us refer to it as the presence exam program, where they would be going in to visit a number of newly registered investment advisors. They're now also looking at a number of advisors who have been registered for a number of years, and really trying to key in on some important topics that we'll get to in a little bit. And as you've seen, after some of these exams, there's been feedback to advisors and to the public on some of the key things they're seeing in those exams, some of the findings, and there was a speech a few weeks ago where basically the SEC tried to say, this isn't necessarily a gotcha type of process, but rather try to point out areas that we should key in on and allow advisors to better prepare, to better put in place their policies and procedures to handle these exams. So if we move on, one question we often get a lot from advisors in particular is, what is this exam process like? How does it work? How do we get selected? Why are we going to get chosen, and when? And those are all good questions that are not easy answers. But what generally we see in sort of the presence exam process is an advisor will be contacted, usually by phone, from someone at the SEC, stating that they will be conducting an examination. There'll be a brief conversation you'll have with them to explain your business. They'll ask some questions, and then shortly, a few days later, most likely you'll receive a document request list. On the last slide of my portion here, when we get to it, I've tried to put down some high-level topics of books and records and documents that you should maintain, which are extremely likely to be requested in a routine exam. Usually a few weeks after production of the documents, and the production they expect to be relatively quick. Usually possibly within a week to 10 days, they would like to see the documents they request. They often then come in and we'll do an on-site portion of examination with a few examiners, and they will usually stay there, although they can stay as long as they prefer, what they feel is necessary for the exam. It's a period of a few days, usually followed shortly thereafter with an exit interview and a letter citing any findings and giving the advisor an opportunity to respond to those findings and explain how they will correct things or their understanding of the actual findings. So that's a sort of broad overview. And again, really just concentrating here on more the routine presence exam versus if something happened to be a sweep exam or more, a for-cause examination, which is also possible. The important thing to remember, advisors, and I guess particularly if those out there have been examined already, there is the possibility that just because you get examined or have recently got examined, there is the possibility that within the next few months or a year or shortly thereafter, the SEC, and they've stated, can do what they call checkup exams, to come back and to make sure that some of the points they found in the examination have been corrected, and they would just want to follow up on that. Okay? On the next slide we get to, I've tried to point out some of the key areas that a lot of us have probably read about that we really do see in these exams. And what I'll do is briefly, some of these topics could be its own webinar in itself, and also some of the detail of this, I think, that some of the other panelists will be covering a little later, so I'll just touch on. But the first topic here, custody, this is a big one. There's been a lot of write-ups about issues regarding custody, and I think a lot of advisors, particularly advisors to private funds out there, whether hedge or private equity, possibly real estate, always want to say, we do not think we have custody. We do not hold cash. We do not hold securities. We don't think we're subject to custody rule. But it's clear that private fund advisors are subject to the custody rule, and there have been a number of issues. So some important things to remember here. If you are an advisor to a private fund, it's getting the audited financials done by an independent PCAOB accounting firm and getting those audited financials to the investors in the fund within 120 days of the year end for traditional investment funds, and for fund of funds, 180 days. The other important thing people often forget is an advisor may say, well, we have multiple funds. We wound one of the funds down this year, so we don't have to do an audit for that fund. And you do need to have a liquidation audit for a final audit for the wind down of any funds in the year that occurred. So just be aware of that. The other thing we often see, which is a problem at times regarding the custody rule and the audits, is people say, this is a fund, there has not been much activity, very illiquid, we're not going to get an audit, our investors have waived it, we're okay. Well, that also is not a reason to not get an actual audit. There are other options, such as what's called a surprise audit, which can replace the financial audit, and something to think about there. Okay. For those advisors that manage sort of traditional advisors to a number of managed accounts, again, very important. You make sure that the custodian of the managed account is sending statements directly to the client, at least quarterly. So, in other words, it's not okay that just the advisor prepares their own statements to send to the client. They also must be accompanied by statements directly from the custodian, and your advisory statement must also state to the client that they should reference the official books and records which are coming from the custodian. So very important. The last thing I'll bring up on custody, often we see an advisor in their fund, in their client account, may hold private certificates or certificates themselves. It's very important to know it's not okay for purposes of custody rule, just keep those certificates in the office in a file cabinet, but they should be on the books of a custodian. So just remember that. Okay. Moving on, accounting-related issues. Mary had a good statement I liked early on where she said, the SEC has the tools to do it and do these exams, and I agree with that. We find the examiners are very well prepared. They are very well trained. There are a lot of people that were in industry, and a number of them we find tend to have an accounting background. So a lot of the routine presence exams that we see tend to focus on financials, both of the private funds and both of the management company. Some of the things we see as hot topics, cash controls. The SEC is looking a lot at how money is moving out of a fund, whether it's for a redemption purpose, whether it's to pay an expense that is a fund-eligible expense, whether the management company may pay an expense and is reimbursed by the fund. All those types of money movements, they want to see controls, and we recommend multiple internal controls there, multiple internal signatures, and often the use of an independent fund administrator, which more and more we've seen the fund administrators involved in these cash controls, okay? They'll obviously look at the audited financials for the fund, and more we see looking at the management company books as well. I mentioned, I think some of the reason for that is there's a lot of times a fund manager may pay an expense and be reimbursed by the fund. And I think they're also looking for just interesting out-of-the-ordinary expenses that may be coming out of the management company. So, again, important to have good books and records not only on the fund side, but also on your management company side or your advisory side. Okay. Expenses is a very important topic, if not, I would say, one of the top 3 topics that go on in exams. And there is a lot of focus on what is being paid by the funds or the clients or the investors. In particular, consistency with your offering documents or your fund documents, where there's usually a very well laid out section on what are eligible expenses to be paid by the fund. That should be consistent in what you're actually paying. Regulators do not like deviation from what you say you are paying, and particularly if there may be situations where consent may be needed from investors if you'd like to put a new expense, to the fund. So just be aware of that. Another big area we see on that is allocation amongst multiple clients of expenses. There's often situations in particular where you may have managed accounts that in the managed account arrangement, that managed account may not be, you may not be allowed to charge certain expenses to that managed account. And however, your fund documents make it eligible to charge certain expenses. Well, there's sort of a fairness analysis here that says just because the managed accounts can't pay, it doesn't necessarily mean it's right to pay the whole expense through the funds, whereby instead the manager should possibly and most likely pick up that portion of the expenses that is not eligible to the managed account but being charged to the fund. So be very careful in analyzing, sort of breaking up fees between clients and the management company. Very, very big issue. I've briefly mentioned here there's private equity advisors on the phone. There was an excellent write-up and speech a few weeks ago by Andrew Bowden from the SEC, where he I believe it was May 2014, he lays out a number of the issues that have come out of exams of private equity managers. And again, as we just said, big focus here is on expenses, and a lot, like I just said, breakup fees, bad deal fees, who are they being charged to, are they properly being allocated, issues with portfolio companies absorbing expenses that possibly the manager should absorb, but they're passing them down to certain portfolio companies. So there's also, a lot of you have probably read, because there was a speech a little over a year ago also by Mr. Blass from the SEC that talked about potential broker-dealer issues regarding private equity firms, particularly something that I guess has been a common practice in the private equity industry over the years, such as transaction-based type fees, where in addition to your management fee and your carry on the liquidation of a position, there may be sort of transaction-based fees, which can be sort of commission-type fees and a broker-dealer regulated activity. So there's concern about that. Okay. Moving on, marketing materials. There's been a lot of write-up over the years on marketing materials. I tried to lay out here some of the key things to think about in your marketing materials. First, what are they? People often ask, and it's your marketing pitch book presentation. It can be deemed, it's a due diligence questionnaire you may put together. It's your periodic letters to investors and prospects. It's speaking on conference panels, and it could be interviews with the media, which is an important topic. And the key here, I think, is to have a process where all marketing materials are reviewed by multiple people and final approval from compliance. I'm sure most of your policies say that, and it's important to follow that. Again, another reason it's important for compliance to be in touch and understand what's going on with the marketing personnel at your advisory firm. Some of the key bullets here I put under key areas of being careful what is in your materials, but if you're showing returns, they should be net of fees, okay? You should have backup for all performance. A lot of people say, well, I didn't register until 2012. Does that mean I don't need my backup to the performance from 2010? no, any performance numbers you're showing out there, you need to maintain that backup, okay? Make sure your disclaimers are good. I think this is where it's important to have your lawyers review your materials and make sure the right disclaimers are on the materials. Be careful if you've left a firm and start a new firm or go to another firm and you want to take your previous track record with you. There's a lot of issues around that. And I would also lastly add, if you're using back tests or hypothetical data, there's going to be a lot of focus on that, and there should be specific language in your disclaimer, stating that this is hypothetical back tested, okay? Moving on, another key area, again, I think regulators have started to spend a lot of time on is the research process. Mary mentioned a lot of concerns around material non-public information, insider trading, and examiners have spent a lot of time meeting with analysts, meeting with the portfolio managers in these exams to understand their research process and who are the groups that the analysts are speaking with in order to gather data and do their research. Expert networks are a very useful source for a number of advisors and their analysts. And it's important, to just have controls around the use of those expert networks. Meetings with public companies, very common practice. Important to understand and maintain a record of meetings that your analysts are having with public companies and going to conferences where public companies are speaking. You've read over the years about idea lunches and idea dinners. And again, the concern there goes to, is there material non-public information that may be getting out there, and if there was, more importantly, the process for reporting it and potentially restricting names that information is obtained on. So my message here is for compliance. Again, those of you who are the compliance officers out there, it's not just reviewing your compliance manual every year and filing your ADV, but it's understanding and meeting with your analysts periodically and your portfolio manager to understand their research techniques, to see if there's policy and procedure that needs to be built around those. Okay. Trading and brokerage, I'm going to touch on here a little, but I think later on in Gary's presentation, he's going to speak a bit about some of these topics I've put here. But obviously, process of trading, allocation of trading amongst multiple accounts, use of soft dollars, how you handle trade errors. Does the fund absorb the error? The client absorb the error? Does the management company reimburse for errors? How is that handled? It's important to have a policy and be consistent and document trade errors. I think a lot of people worry that if a trade error is made, it looks bad, but it's important to show you understand policy. The trade error goes to the attention of the compliance department and it's addressed properly. And soft dollars, again, having, I think, some important disclosure area in your offering memorandum for your fund or funds of what you're allowed to soft dollar, what you're eligible for. And then I'm going to leave Reg M to later conversation. I know it's in some of the later slides, but this has been a huge area of concern and fines to advisors over this particular, in the last year or so. There were a number of cases, a number of advisors that suffered, penalties due to Reg M violations, which deals with shorting around secondary offerings. So important to understand that and have policies for that. And trading and brokerage, I think it's important for compliance to be, again, involved in this area. Perhaps operations deals with trade reconciliation and things like that, but periodically compliance should be looking at this issue, making sure allocations are done appropriately, whether it's on a pro rata basis or not, and if it is not, documentation of why trades weren't broken up in a pro rata manner. The last topic I'm going to touch on today is cybersecurity, which I understand there's another webinar coming up on this shortly, and it is a hot topic. As I mentioned, a lot of our compliance officers are now concerned. They now are becoming the chief technology officer as well, with some of the recent releases out there from the SEC that this is an area of concern for them. They are in the midst of conducting a number of exams on advisors regarding just cybersecurity, and we have seen this come up as a topic in our clients' SEC routine exams. So it's important, the SEC said, to have policies and procedures to address, detect, and handle cyber breaches. It's also important that you have policies and procedures to to conduct due diligence on certain service providers, cloud providers, on what their controls are around potential cybersecurity breaches. So, right now I think it's important people should look at a recent release the SEC put out in April. Probably most likely sit with your IT internal people or vendors, go through that, assess what your internal risks are, assess what your risks regarding technology with your service providers are, and really start to sort of build out a program for cybersecurity needs. This is also, I'll add one little piece here related to insurance. Some of you may have D&O, E&O policies from years ago where cybersecurity wasn't an issue. Probably important to go back and review those policies to see if if it's important enough for you to have those policies address cybersecurity breaches, and I'm sure we'll talk about that along the way as well. Good. The last slide here, just some other key things to think about. Sometimes we think it's not a big concern, but in the eyes of a regulator, or actually as well an operational due diligence person looking to make an investment, but sharing offices with multiple advisors and having controls around information flow or just privacy concerns of having clean desk policy. Are you walled off from the other advisors in this space? Value-added investors, something to think about, where if there's any investors where there's the perception they may be giving you information and they're a high-level executive of a company might be in your portfolio. Those are things to think about. Outside business activities kind of goes in line a little with personal trading. Be aware of that. And I think email communication review is important for compliance officers these days to have policies. A lot of you have quality email retention systems, but to use those systems to do kind of guided searches and important searches that relate to important areas of your compliance program. And then for your reference to take home with you, again, some key topics and key documents that we see frequently requested in regulatory exams. Thank you.
Perfect. Next, we're going to have Gary Stein from Schulte, Roth & Zabel addressing SEC enforcement actions. I'm going to turn it over to you, Gary.
Thank you, and good morning or afternoon, everyone. Let me start with some statistics, because how better to make sure that everybody's paying attention. You can see from our slide that the number of enforcement actions actually declined last year by about 7% compared to the 2 prior years. But before people start popping open champagne bottles, the SEC was quick to announce at the same time that what they call their pipeline, that is to say cases under investigation, is very full indeed, and indeed the number of investigations was up last year, so last year's drop in enforcement actions may well be reversed this year. The really interesting thing about these statistics, particularly when you look at them over time, is the degree to which investment advisor cases have really moved to the forefront of the SEC's consciousness. In the last 3 years, investment advisor or company cases has remained relatively constant, 146, 147, 140. That's a full 20% of the SEC's overall docket, and it represents a big change from where the SEC was just a few years ago in the late 2000s, when the numbers were more like 79, 87, 76 per year, and only representing 11, 12, 13% of the SEC's overall docket. So there's been a very major uptick in investment advisor cases. And in fact, of the 9 or so different categories that the SEC uses in these statistics, investment advisors and companies is now the biggest bucket. So congratulations, everyone. We're number 1. And by the way, that doesn't even take into account insider trading cases, which is in its own separate bucket. When you step back, and I think it's worth doing for a moment, and think about this from a policy perspective and a resource allocation perspective, it's not clear why targeting this space, as Mary O'Connor aptly put it, makes a lot of sense. It used to be that the biggest bucket for the SEC was cases involving financial fraud and issuer disclosure, which is what we tend to think about when we think about the SEC's core mission, protecting the little guy, the small investor being preyed upon in the public markets by the wolves of Wall Street. But those sorts of cases have actually significantly decreased by more than half in this decade as investment advisor cases have increased. And So we're seeing a shift in the SEC's priorities away from protecting the little investor and in favor of protecting the biggest and most sophisticated investors who actually are in the best position to protect themselves contractually and if it comes to it, through litigation. In a world where law enforcement resources are necessarily limited, one might call the SEC's recent focus on investment advisors curious. One might even call it wrong. But since, and if we could go to the next slide, please, whether it's right or wrong, it is the reality. Everybody needs to be conscious of the types of cases we're seeing in this area. I've ticked off some of the major categories here. I'm sure these topics are familiar to most of you. Chris discussed many of them, and I won't go through them all, except to emphasize two things. One is these issues are not just OC issues. They're not just examination issues. These are the subject of enforcement actions, and the SEC has been very aggressive in each of these areas listed here. And the second thing is to highlight something that Mary mentioned, which is with the exception of insider trading, these areas do not, by and large, require the SEC to prove what we call scienter or fraudulent intent. Systems and controls, as Mary mentioned, is behind a lot of these cases. Or the substantive rule of liability doesn't require fraudulent intent. The SEC really has been ratcheting up its use of Rule 20648 under the Investment Advisors Act, which allows them to go after false or misleading statements or omissions made to investors without requiring fraudulent intent. Negligence is enough. So if we go to the next slide, please. Let's say whether it's in one of these hot-button areas or another one, you are the lucky recipient of a subpoena or a request for documents from the SEC. What are the types of things you should be thinking about? In this forum, I can't not put front and center the importance of notifying your insurance carrier. Insurance policies typically require prompt notice, and you could prejudice your rights if you forget to give prompt notice to your carrier. Sending around a document preservation notice within the firm to make sure that people are preserving and not discarding relevant documents. Seems straightforward, but there's actually a fair amount of complexity around it, such as who should the preservation notice be sent to? On the one hand, you want to cast the net as wide as possible to make as sure as possible that you aren't later criticized for failing to preserve documents. On the other hand, there can be significant downsides to simply sending the notice to everybody in the firm. By spreading knowledge about the investigation, you can lower employee morale. You can result in outside constituencies finding out about the investigation. It can even lead to a negative story in the press. So that issue needs to be carefully thought about. Should the preservation notice mention that there is a subpoena? It's a good idea from one perspective because people might take it more seriously. On the other hand, you don't have to do that. What you need to do is make sure that the documents are being preserved. And again, you don't want to unnecessarily spread knowledge by means of a document preservation notice that you're the subject of an investigation. The next topic we have is, whether you need to retain outside counsel. You can imagine our perspective on that issue. We think it's a good idea. But the truth is it's not always necessary. If it's clear that you're just a witness, there's no reason why you can't handle the document response in-house. In a more serious case, you also have to consider whether individuals need their own separate counsel, separate from the firm's counsel, and even within the firm, whether the fund on the one hand needs separate counsel from the manager, and there are a host of considerations around those issues. Protecting the attorney-client privilege. You want to make sure you're doing that. Remember, communications between business people, even in the midst of an investigation, are probably not going to be privileged. So you want to make people understand that everything needs to flow through the in-house counsel, and that they certainly shouldn't be talking about this outside the firm. Disclosure issues are also important. Probably the most important one is, do you need to disclose the investigation to your investors? The answer to that depends on the good old question of materiality, and there's no bright line test. You have to look at all the facts and circumstances. Things like, are you in the middle of a capital raise? If so, that may militate towards disclosure. What is your redemption schedule? Is a redemption date about to come up soon? Do you have any commitments in your side letters to provide notice to particular investors of these sorts of matters? So let me move on to the next slide and talk a little bit about some of the new tools that the SEC has in its bag of tricks, and I won't go through all of them. Let me talk about whistleblowers. The Dodd-Frank program does seem to be bearing fruit. Just this week, the SEC brought its very first case for alleged improper retaliation against a whistleblower, and that case actually involves an investment advisor by the name of Paradigm Capital. The whistleblower was the head trader, told the SEC about potentially prohibited transactions with a related broker-dealer, and after Paradigm learned that the head trader went to the SEC, according to the SEC press release, Paradigm retaliated against him by removing him from his head trader position, tasking him with investigating the very conduct he reported to the SEC, changing his job function from head trader to full-time compliance assistant, stripping him of supervisory responsibilities, and otherwise, quote-unquote, marginalizing him, which all sounds pretty bad, but when you read the order instituting proceedings, you see, or at least I saw, some interesting facts. First, it seems that Paradigm told the whistleblower they needed to remove him temporarily from his positions because they needed to investigate his actions. And that's very usual in a situation where a company has some reason to be concerned that a employee in a key position may have himself engaged in misconduct, which seems to be what Paradigm was doing here. Second, Paradigm continued to pay the whistleblower his full salary and benefits, so he wasn't retaliated against financially. And third, and this in many ways was the most interesting, Paradigm appears to have been acting with the advice of counsel throughout in terms of how they dealt with the whistleblower. So the lesson I draw from this case is that you really have to be very careful about how you deal with whistleblowers. Even when you may think you're doing the right thing, the whistleblower may spin it in some other direction and convince his buddies at the SEC that he's a victim of retaliation. Let me talk about administrative proceedings because, again, just last week, the SEC Enforcement Director, my former colleague Andrew SRZ-IT, said that he plans to bring more cases as administrative proceedings rather than as lawsuits filed in federal district court. The SEC has a significant home court advantage when it does that because the judge will be an administrative law judge who sort of naturally favors the SEC as opposed to a federal district judge. And the only real appeal you have is to the commission itself. So that's a significant development. It may or may not be related to another development that's been getting some press, which is the SEC's rather mediocre record in court recently. The SEC has 4 wins and 5 losses in jury trials this year, which isn't much better than the Mets, or to be even-handed about it, the Yankees when Masahiro Tanaka isn't on the mound. So finally, with regard to that, people probably shouldn't draw sweeping conclusions from these sort of sample sizes, but people will anyway, and we may well see more defendants opting to put the SEC to its burden of proof at trial rather than cutting the best deal they can. If we could turn to the next slide, and the final slide for me. Speaking of cutting the best deal possible, a brief word about the evolution of the SEC's policy about requiring admissions of liability. In 2012, Enforcement Director Kazami announced that the SEC would begin to seek admissions of liability from parties who were also pleading guilty in a related criminal case. That wasn't such a big change, but last year, the new SEC Chair, Mary Jo White, announced a more significant change, making clear that the SEC may require an admission of liability in any case based on a number of factors, including how many investors were harmed, the egregiousness of the conduct, and so forth. And the SEC has been doing this, not often, but they have been, including in the Harbinger case that was referred to previously. Although the SEC denies there's any causal connection, these policy changes have all taken place after a federal judge here in Manhattan, Jed Rakoff, severely criticized the SEC for negotiating a settlement with Citigroup without getting Citigroup to admit the facts or otherwise getting to the truth. Earlier this month, a recent development, the Second Circuit issued its decision reversing Judge Rakoff's ruling in the Citigroup case, a much-anticipated ruling, which makes clear that, at least in the Second Circuit's view, it is not the function of district judges to pressure the SEC into requiring admissions of liability, and that that's really a job for the SEC. So it looks like the outside pressure from the judiciary for these sorts of admissions of wrongdoing has abated somewhat, but the SEC does have a new policy, and it remains to be seen whether and under what circumstances they will insist on an admission of liability, an issue that has very important implications for, among other things, insurance coverage. And I'll now turn it over to my friend and colleague Ted Keyes to talk about that and other insurance-related issues.
Good morning. As Gary said, the SEC policy on admissions and settlements appears to be evolving, and to the extent, notwithstanding the recent Citibank ruling, to the extent that that results in more pressure on those under investigation to make admissions in settlements with the SEC as opposed to settlements where there's neither an admission or a denial, that has significant insurance implications, both for an individual who might be doing the admitting as well as possibly for other individuals and potentially for the entity for whom the individuals work. So I'm going to focus on that today, and the focus of the insurance issue is really mostly on the conduct exclusions, which the operation of which will determine to what extent an admission has a significant implication for the individual. With respect to other individuals and the entity, the non-imputation and severability clauses are the more important provisions. But first, let's talk about defense costs, and we can move to the next slide, because in the context of an SEC investigation or enforcement action, what we're really talking about under your insurance policy is whether you can get reimbursement for defense costs, because disgorgement's not going to be covered under the policy, and fines and penalties are not going to be covered under the policy, but possibly your defense costs can be covered, and those can potentially run into the millions of dollars depending on the scope of the investigation. In your D&O policy is different from the standard general liability policy, which has a duty to defend clause. Under a duty to defend clause, such as in the general liability policy, the insurance carrier has to pay first dollar defense costs as soon as there's a suit or allegations that might be covered under the policy. Under the D&O policy, the insurer only has a duty to advance defense costs for covered claims only. And that's different because there's a bit of a time lag between when you spend your defense costs and when you get reimbursed. And it also gives the carrier the ability to allocate where there's covered and uncovered claims. The insurance carrier may only advance a portion of the defense costs. But most importantly for this presentation is it also gives the carrier a potential right to clawback if it turns out that defense costs that it's been advancing are for claims that turn out to not be covered. So you may be getting reimbursed for defense costs, but if the conduct exclusion ultimately applies, the insurance carrier may have a right to clawback. And while insurance carriers in the past have typically there haven't been too many clawback actions, there have been more lately, and depending on how the history of admissions goes from here on out, we may see more of them. If we can go to the next slide, we'll focus on the conduct exclusions, because the conduct exclusions, what they do is they exclude coverage for claims arising out of deliberate fraud, criminal acts, dishonest conduct, willful violations of law, illegal profits that you're not legally entitled to. But in a good insurance policy, and most of the insurance policies have this language now, those conduct exclusions will only apply if there's a final adjudication that the bad conduct took place. And typically, in a good policy, that final adjudication has to be in the underlying action, and the final adjudication has to be non-appealable. So, if we can go to the next slide. So the issue becomes, if you're in a position where you're going to settle with the SEC, you need to consider whether, if you're going to make an admission, is that admission, the critical question is the admission you're making in the settlement going to be considered a final adjudication? because if it is considered a final adjudication, at least for the individual making the admission, loss is going to be excluded under the policy. Defense costs going forward are not going to be covered. There's a potential for clawback of defense costs that have been previously reimbursed, and there's likely going to be no coverage for related civil actions. So it's a very critical question, and now insurance doesn't always drive your decision-making, obviously, but to the extent insurance is important, it's a critical question to determine whether or not that admission is going to be considered a final adjudication. Let's go to the next slide. Now, what constitutes a final adjudication? There is limited case law on this issue, in part because historically a lot of these SEC actions are settled without an admission. It's now, to the extent they're going to be increasing admissions, it's going to be more important, and there's going to be more case law, and there's a good chance that insurance policies are going to have to be clarified. Take some examples. Now, a judicial ruling on the merits after an appeal is certainly a final adjudication, but it's key to have that final non-appealable language in your policy, because the courts have shown an inclination to strictly interpret what's a final adjudication and a non-appealable one. For example, in the Dupree case, the insurance carrier was required to continue funding the defense even though the CEO had been convicted of bank fraud because the CEO had filed a motion to set aside the verdict. So the court said even though there was a conviction, the motion to set aside the verdict meant that it wasn't final yet, and that the insurance carrier, at least for the time being, had to continue to advance defense costs. A guilty plea is probably going to be a final adjudication as well. In the Hurley case, the court held that the CEO's guilty plea was a final adjudication that established the willful violation of the statute and triggered the conduct exclusion. There's at least one case out there where a default judgment was considered a final adjudication. In the Rice case, there was a default on the fraud claims, but there was a trial on damages, and the court found that that judgment was sufficient to trigger the final adjudication clause under the conduct exclusions. Now, it gets a little grayer when you have a settlement, either approved by a court or an administrative settlement. That issue hasn't been litigated yet, whether the mere what you might characterize as a mere rubber stamp by a court, whether that constitutes a final adjudication. The terms of the settlement may be important. Does the settlement agreement have specific admissions regarding an individual's conduct? Does the settlement restrict the position that an entity or the individuals can take in subsequent cases? Those are issues that haven't been addressed yet, if we're going to be seeing more admissions, we're either going to be seeing clarification on those issues in the courts, or we're going to need to see policy language that clarifies exactly what constitutes a final adjudication when an insured is faced with trying to resolve an SEC action, because you can be, to some extent, you can be placed in a somewhat of a catch-22 situation where the best thing for the individual or the business is to resolve the case through an admission, but in order to do that, you may be tossing aside any insurance coverage. We can go to the next slide. Primarily, the admissions, if there's an admission that's considered a final adjudication, that's going to preclude insurance coverage for the person making the admission. The non-imputation clause is another key clause in the policy, because what it does is protect the innocent individuals first, so that typically conduct exclusions in a good policy will have a non-imputation clause that says the bad acts of one insured are not to be imputed to other individual insureds. And this way, if there's one bad actor who pleads guilty, the other individuals who may be under investigation will not be precluded from insurance coverage because of the one bad actor's guilty plea. With respect to the insured entity, presumably entity that employs the individual, in some cases the bad conduct of one individual will be imputed to the entity for purposes of determining whether the conduct exclusion applies. Most policies limit that imputation to where it's someone like the managing principal or the CEO or the CFO, or in some cases the GC. The activities of those individuals, if they make an admission of guilt, can be imputed to the entity and preclude coverage for the entity. The final slide is similar in that severability language addresses representations in the application. And so if you make a representation in the application that turns out to be a material misrepresentation, typically the person who signs the application and anybody with knowledge of the misrepresentation is going to be precluded from insurance. But again, there's a non-imputation aspect to good severability language, which will prevent the knowledge to be imputed to innocent individuals. And again, in some cases, if those individuals are the CEO or the CFO or the managing principal, it's likely that the knowledge is going to be imputed to the entity. So, in some, admissions in settlements with the SEC can have a significant impact on insurance rights. Now, as I said, I know insurance doesn't always drive the decision-making here, but it's important to understand the consequences of those admissions for the individual making the admission, as well as potentially for other individuals and the entity. And a lot of these issues have not yet been addressed by case law because there haven't been a lot of admissions in these cases. So we're going to need to see either a clarification of policy language or a clarification of case law to address the different varieties of circumstances where these admissions can arise. I think with that, I will turn the speaking over to Bob Herm.
Good morning. Good afternoon, everybody. I'm going to walk through briefly insurance coverage aspects with respect to SEC investigations. I have to state that my statements I'm giving are my personal opinion, and they're not an interpretation of any insurance contract issued by Access or other companies in the industry. The SEC investigation is a multi-step process. I'm going to walk through it because it's very germane to how insurance coverage applies. The stage of an SEC investigation relate to, first, a triggering event, which can be basically anything, a news article, investor complaint, whistleblower issue, pick your triggering, you pick anything basically. The next step is informal inquiry, which usually involves general requests for information from an advisor with respect to document production. They may ask individuals to voluntarily come in and testify. There's no jurisdiction to compel testimony at this point in time. So you're free to tell the SEC you're golfing that you don't want to talk to them. It may not be the brightest idea, but that is your right at that point. It's a very low threshold to open up an informal inquiry for the SEC. It's, I think, widely given to the local field office at the SEC to open up an informal inquiry. The formal order of investigation is the next step. This is usually by the enforcement director, and they've delegated, I think, to local field offices about 5 years ago, additional jurisdictional powers to issue formal orders of investigation. When it goes formal, the SEC has a subpoena power. They can compel document production. They can also compel document production from third parties such as banks or counterparties to trades. They can also have authority to administer oaths with respect to testimony, which is usually the next step after document production. If the SEC believes they found improper conduct, they generally give the right, they issue a Wells notice, which basically gives a general outline of why they intend to initiate an action against against individual or entity. And it gives the individual or entity one last chance to explain or put into submission basically to indicate why they shouldn't be pursued further. So as far as the insurance coverage implications of how this works through, basically you have to get into an insurance company D&O or E&O policy, you have to pass through the definition of claim. That's the threshold issue. Then within that, then professional service is the next issue based for threshold coverage for investment advisor type issues. So the germane elements of claim with respect to SEC actions are, one, it's a multi-part definition. One part is a civil, administrative, or regulatory investigation against any insured commenced by a subpoena. In note, subpoena is usually synonymous for the previous slide with formal order of investigation. And some policies have a specific clause for the SEC also, which again is generally similar. It's usually a service of subpoena upon individual, any individual, or service of subpoena upon an entity, where they expect basically the SEC is identifying the entity the target they might pursue at some point in the future. So some policies are a little more permissive with respect to allowing coverage for subpoenas relating to insured persons. Although SEC subpoenas may often say, in re XYZ Corporation, and my understanding, they don't often name specific individuals at the time of the subpoena, because the subpoena gives them rights to take depositions anyways. So it is a little unusual, from what I understand, to have an SEC subpoena indicate it's targeting specific insured persons. There's no outside SEC to do that. Another issue is you have to basically have a wrongful act, which I'll get into in a second. Now, I guess the question that comes up is, service of a subpoena. The policies aren't priced at this point in time. The structure of the premiums charged by the insurance companies don't really contemplate informal investigations. There's a fine line as far as sometimes you won't know if they're formal, even possibly. The SEC may issue if they issue a subpoena, they've gone formal. There are certain cases where it's not entirely clear what stage the investigation is at. There can be issues with respect to that. And also, generally, the insurance, subpoena is not intended to cover, correspondence during a routine examination. If the SEC does a presence exam and they find potential issues, external counsel is engaged, there's back and forth with respect to a particular issue in the presence examination process. That's still generally outside of the subpoena process. When it hits the subpoena process, then it might be covered. So, and another related issue which comes up also with respect to coverage positions is the insured a target. The definition of wrongful act usually requires, it can be broadly defined as negligent act, error, omission, or alleged breach of duty. Is the SEC making a broad industry sweep where they're just gathering data, which often happens, or is the SEC targeting a specific company for improper conduct? If it's a routine industry sweep, those are usually deemed to be outside contemplation of the insurance contract, where the insurance contract is meant to protect the entity, insured persons, where they've alleged to commit a wrongful act. So those are some of the issues that tend to come up as far as whether there is or isn't coverage for an SEC process. Some of the issues, there's been a lot of give and take between the insurance brokers, community underwriters, with insurance brokers, coverage counsel, of course, incessantly asking for broader coverage with respect to informal investigations. It's basically been turning into a bit of a standoff. It seems like where the industry's come down heavily right now. For the most part, there's, it's like this formal investigation. One thing that's come out in the marketplace in the past, very recently in the 1940X space or the non-1940X fund space, is something called investigative cost coverage. This started off in the public company directors and officers liability coverage space about 2 or 3 years ago, where it's basically related to the SEC wants to talk to a natural person about the business of the entity. It basically allows, and if that person wants to engage their own separate counsel, the insurance carriers will grant coverage for that insured person to obtain their own counsel to prepare to talk to the SEC. So, one of the threshold issues, I'll walk through it real briefly. As far as sample wording we see in the marketplace, which, this is more in the public space, but it's working its way, like I said, into the hedge fund space. Usually a verifiable request by an enforcement body that the insured person appear in an interview or produce documents in their sole possession, which will be rare, of course, relating to the activities, with the company. This wording pretty routinely excludes standard industry sweeps, audits, examinations. And the costs covered usually include, like I said, defense costs, which means prepping a person to talk to the SEC. Having said that, it sounds like it's limited coverage. We've seen defense bills actually for prepping people for SEC discussion of $500,000 too. So much as it sounds like the scope is, limited in some respects, but it has to be separate counsel generally. But I guess the other issue too is it doesn't require a wrongful act usually. And it also doesn't have any formal trigger of a subpoena or formal order of investigation. So it sets the bar lower, to give some insured persons, if they want to engage their own counsel, some additional protection. currently we're seeing this. I would say it's limited largely to larger investment advisors and hedge funds, just by virtue of the fact that they have higher policy deductibles, and to the extent that the underwriting community has no real loss experience with this type of coverage in the SEC investment advisor space, it's a bit of an unknown as far as what the loss exposure could be. Per previous slides, SEC investigations are 20% against investment advisors, which you can assume losses are 20% for insurance carriers based upon that, and plus additional, actually more than that due to hourly rates going up. So this is like one very new issue out there in the insurance coverage space. With respect to previous slides discussed, previous speakers discussed the final adjudication issue. One pretty common issue that comes up with respect to insurance coverage is definition of loss, which pretty much every policy says includes matters uninsurable under applicable law. The issue there often is public policy forbids alleged wrongdoer from retaining from having to pay back improper benefits, then obtain insurance recovery for their improper benefit they had disgorged to a third party. This comes up pretty commonly in SEC proceedings, because it's fairly common for the SEC as part of the settlement to require the alleged wrongdoer as part of the settlement to disgorge any benefit the firm or individual obtained. This also comes up in civil litigation, where, for example, in a fraudulent conveyance issue, fraudulent conveyance claim will be against a fund potentially to disgorge the proceeds of a fraudulent conveyance. It also comes up in that context as well. And also fee litigation too. This also arises, even private plaintiff fee litigation. There's a pretty good body of case law in New York. It's been litigated quite heavily, especially given the number of advisors and funds in New York. The case law has gotten to be quite well developed. It's pretty black-letter law that the disgorgement related to amounts personally received or specifically received by an advisor or fund, they have to give it back pursuant to the investigation that's not covered. There was a case about 6 months ago where the SEC called a settlement disgorgement, but it was actually third parties who received the improper benefit. The SEC made the named defendant, quote, disgorge profits, but they never received the profits in the first place, so it went to third parties. In the insurance coverage litigation in that case, a New York Court of Appeals found that it wasn't true disgorgement because they never actually received the profits. They never received the proceeds, even though it was called disgorgement. So that case is still ongoing. I think it was kicked back, to the district court. Let's see. One issue, too, is that pretty much all insurance policies now include a carback where even if the matter sought is uninsurable, defense costs attributable to defending the claim are still covered. It's usually a clause saying loss other than defense costs won't include taxes, fines, penalties, matters uninsurable by law. That's gotten to be fairly standard following a case where an insurance carrier was absolved from having to pay defense costs where the underlying matter was uninsurable. Coverage for another issue that comes up is coverage for fines and penalties. New York is generally fairly strict. I didn't put this in the slide process. I want to do a quick discussion on fines and penalties. New York is pretty strict in terms of insurance regulation, no coverage for fines or penalties. But there is some coverage in the advisor marketplace for Foreign Corrupt Practices Act violations and UK Bribery Act violations for civil fines and penalties assessed pursuant to specific statutory sections against natural persons, and often where the conduct is not intentional, to stay within public policy parameters. So there has been a little bit of opening with respect to fines and penalties in the past, I'd say year and a half plus or minus in that particular space. The last issue, real briefly, I want to run through is what are called Side A directors and officers insurance policies with different conditions. These are policies which the only insured parties are natural persons. The advisor, any fund, is not an insured party under this policy. It only applies also in a very fine specific cases where the insured person is not indemnified, either due to the advisor not being financially able to indemnify, the advisor makes a discretionary refusal to indemnify. It's also excess of any underlying insurance coverage available too. So it's got a fine scope of limited scope of coverage, but it also has very few exclusions, too. The policies often have only one exclusion right now, which is basically the final adjudication trigger as far as civil or criminal actions. So, I mean, these policies are basically meant for backstops to protect natural persons who are directors or officers from their insurance policy their underlying insurance being exhausted due to the entity having to pay defense costs, and also like judgment refusals to refuse to indemnify. So that's what I wanted to run through. I think that goes through my issues.
Thank you very much. Thank you very much, Bob. And I really want to thank all of our speakers for some tremendous comments. And we are going to open up to Q&A. I believe you have to press star 1, and the operator will open up your line so that you could ask some questions. I guess just one question that I had initially with Chris Lombardi, who was speaking on allocation of expenses. And the question was recently posed of me, can I allocate this expense of the D&O policy to the fund and the managed accounts? You touched upon that. What is the rule there, and does there have to be specific language or agreement with the managed account in order to allow for that?
And that's usually, I think, as you sort of said, Shari, on the fund documents, there's usually clear disclosure of what can be paid, hopefully, and often that can be built in, whether they pay the entire cost out of the fund or there's a split between the fund and the advisor. And I think the more difficult area comes with managed accounts because everything is sort of built into this investment management agreement. So I think absent probably being built into the investment management agreement, it might be something where those costs would more be allocated to the fund manager versus the fund for that. But again, I think it's important, as you're drafting with your lawyers these managed account investment management agreements, think of these things ahead of time and try to, sort them and include them in the agreement if that's what you want to do.
Thank you. I don't know, Richard, if you have any comments that you'd like to make as we wrap up, or...
Well, operator, do we have more questions, or...?
Do we have questions, operator? If anybody would like to star 1, could you...
Thank you. We will now begin the question and answer session. To ask a question, please press star and then 1. Please record your name clearly when prompted. Your name is required to introduce your question. To withdraw your request, press star and then 2. One moment for the first question. Our first question comes from the line of Ms. Katrina. Ma'am, you may now proceed.
Hi, thank you. It's Katrina Fletcher speaking from London. I wondered from the panel what advice they would give on managing the potential conflict of interest that can arise between an insured entity, with D&O insurance, and an individual director who might then be subject to an SEC investigation.
I'm sorry, we had trouble hearing the first part of that question. Can you repeat it one more time?
Sure. What advice would you give on managing the potential conflict of interest that may arise between an insured entity and an individual director subject to an SEC investigation? Can you hear me okay?
We heard you. We're all looking at each other. Gary, Ted, you guys want to take a swing at that?
Well, yeah, I guess at the outset, both the individual director and the insured entity should have insurance coverage, and if they do, or even if they don't, I think the way to manage the potential conflict of interest is for them to have separate counsel. Typically, insurance carriers will agree to that if there is a potential for a conflict of interest. I don't know, Gary, if you have anything to say.
Yeah, and it's Gary Stein. Whether separate counsel is necessary for a particular individual depends, on the facts and circumstances. But generally, if it looks like the SEC may be thinking of bringing charges against an individual, not just an entity, it's a good idea for that individual to have separate counsel because he or she may have defenses, that might put the firm in a potentially a negative light, or at least have conflicting interests, in terms of issues such as, whether to waive the attorney-client privilege, and just a host of other issues. You generally will want to have separate counsel for an individual who is also in the crosshairs.
And can I ask, in addition to that then, are you finding that the insurers are allowing individuals to choose counsel, or will those mostly be selected on their behalf by the insurer? Will they have choice of counsel?
I'd say almost all insurance policies in the U.S. allow choice of counsel with the consent of the carrier, which is generally, I wouldn't say a rubber stamp, but for the most part, it's granted reasonably freely.
Yeah, seems to be the
Right.
case.
You can run into some issues about, the rates, and you may end up in a situation where you have to negotiate a rate agreement. But otherwise, typically, as Bob said, consent of counsel with the approval of the insurance company.
But why would you choose anyone other than Schulte Ross is the real question. Anyhow, operator, can you find our next question?
I actually have a second.
Thank you.
Sorry.
Your second question?
So my second question was just a general one. What advice would the panel offer to the board of an SEC-regulated fund manager entity to consider on an annual basis as part of their review of SEC obligations?
I think it's important, this is Chris speaking, that, you do conduct an annual self-assessment, which is extremely important and required, and it's a document that's often asked for in these SEC exams. And I think, each firm is a little different, possibly depending on some riskier areas. So, I think it all goes into sort of a bit of a risk analysis of your firm. If it's sort of a hedge fund with a lot more trading activity, that may be much more of a focus, trading and allocation and best execution than a private equity firm would be. I also think that as you read a lot of the releases the SEC puts out on, hot topics and things they're finding and talking about from their exams, that's probably an area you want to cover because it's something they're going to focus on. I.e., I think cybersecurity is probably something relatively new to a lot of advisors and something you may want to think about in your sort of this year-end self-assessment review.
Operator, next question.
Thank you. Once again, if you would like to ask a question, please press star and then 1. To withdraw your request, press star and then 2.
We will, I don't know if there are any further questions. We will certainly make the slides available via email, so you will have them for your records. This webinar has also been recorded and will be available for anybody who was not able to hear completely, or I know there's if anyone had any technical difficulties. As we said, this was an initial launch of our webinar series. Our next webinar will be on July 17th on the topic of cyber liability. We will be sending an email out on that shortly, so we look forward to having everybody join for that session.
Perfect.
Thank
and once
you.
again, we'd like to thank all of our panelists, Robert, Gary, Ted, Chris. Gary will be hosting our baseball seminar coming up as well. Is that right? Anyhow, so thank you all for joining us. We'll be talking soon.
Thank you.
Thanks.